Okay, Kayla, if you want to go ahead and hit record.
Just started it.
Okay, we will go on the record. Good afternoon. It is now 1:30 p.m. June 7th of 2023. The commission has set aside this time today for a motion hearing in the matter of the staff of the Missouri Public Service Commission complainant versus I-70 Mobile City Incorporated, doing business as I-70 Mobile City Park respondent. And this is case number WC-2022-0295. And the motion hearing today is on the motion to compel answers to certain data requests and I-70 Mobile Park's opposition thereto. Because of the court reporter shortage, we've had difficulty scheduling court reporters. Are there going to be witnesses for this hearing?
No, I don't have any.
I don't have any.
Okay. What I'm going to do is we are recording this hearing and that recording will then be transcribed, okay?
Okay.
All right. My name is John Clark. I'm the regulatory law judge presiding over this hearing today, if I didn't say that already. And I'm going to ask counsel to enter their appearance for the record.
My name is Carolyn Kerr. I'm counsel for Public Service Commission.
Thank you, Ms. Kerr. And on behalf of I-70 Mobile City Park?
And Stephanie Bell with Ellinger Bell on behalf of I-70 Mobile Homes. And I've also got Annalie Hobbs, who is a law student at Mizzou, who is joining us on the call as well. Thank you.
Okay, that is fine. I hope she enjoys this proceeding. Okay, is there anything I have to take up before we go into arguing the motion? Are there any preliminary matters? Staff?
I don't think so.
I-70 Mobile City Park?
Your Honor, I just wanted to make sure you received the 5 exhibits that I emailed over this afternoon.
I received a Dropbox that I was unable to access, but then you had sent over, it looks like 1, 2, 3, 4, and a singular. Yes, I have them and it appears that I can access those.
Okay.
So,
Yeah, and I was able to access them as well.
okay. All right. It is staff's motion. And since no party is presenting witnesses, you staff, you can go ahead with your argument.
Thank you. May it please the court. Staff filed this motion to compel answers to certain data requests to tie up some final loose ends in this case. We're trying to get as much information as we can to adequately respond to I-70 Mobile City Park's motion for summary determination and finalized discovery. Unfortunately, I-70's failed to delay or refuse to provide certain requested documents, making this motion necessary. We've tried getting this information multiple times and in many different ways without filing anything with the commission. But as we discussed and made clear in our discovery conference back in March and in my written motion, we've had little success. Our motion does not even ask for much more information. It actually asks for I-70 to do what they're required to do and obligated to do, which is to update information and answer discovery requests. In my motion, I asked for updated responses to 5 DRs. Since the filing of my motion back in April, counsel for I-70 actually responded with updates to 2 of them, specifically DR numbers 19 and 20 on April 27th. So we're here today, 3 months later in June, only asking for updates to 3 DRs, specifically DR numbers 14, 42, and 44.
14, 42, and 44?
Correct. Originally, DR number 14 asked for an explanation of the billing process for water and sewer service provided to I-70 tenants and for 5 years of customer bills. In July of 22, I-70 only produced 5 documents: a sample bill, billing histories for 3 months of 2020, a software ledger from a billing program, and one showing water usage for October 2020 to June 2021, and a summary of I-70's billing and payment of utility service from May 2020 to June 2021. Their argument was that 5 years of documents was overly broad and burdensome, and that the staff and commission doesn't need to see all the bills to determine whether I-70 is engaging in the unlawful provision of water and sewer services to the public for gain. I-70 was making the relevancy determination for the commission as to what documents you need to see to make your legal conclusion. My motion to compel, however, narrowed what staff was asking for to copies of bills dated July 1st, 2022 to the present. Basically 11 months of bills instead of 5 years of bills. We agree 5 years of bills are allowed documents, so we decided to narrow our motion to ask for information about what I-70 Mobile City Park is doing now. What is their current state of business? That question is very relevant to the question before the commission, and I-70 has a duty to provide the staff with that information and fully and completely answer DR number 14, at least the updated request, which is to provide copies of all customer tenant bills for water and sewer services dated July 1st, 2022 to the present. And because they answered DRs number 19 and 20, we know that that's 56 tenants, 56 water bills for water, 56 bills for sewer. And then with regard to DR number 42, that DR asked for copies of all water bills I-70 received from the Public Water District for the past 5 years. Staff wanted to see how much I-70 was being billed by the water company before it calculated the bills it sent out to its tenants, basically to see what the gain was. The markup was between what they paid the water company and what they charged their customers. In July 22, I-70 responded that it didn't have any bills used to calculate tenant bills, but nevertheless attached 1 year's worth of water bills from Bates City, Missouri, June 2020 to June 2021. Again, I-70 argued that 5 years of information was overbroad and burdensome, and that 1 year's worth of bills was sufficient information for staff and the commission. Again, my motion to compel narrowed the request for water bills to the year July 1st, 2022 to the present. It's not I-70's place to determine what's relevant or sufficient for the commission to make a decision. Staff asked for the information in a DR in accordance with the rule. The information requested by staff is relevant. Staff is entitled to get the documents requested, and I-70 has a duty to provide the staff with that information and fully and completely answer DR number 42, at least the updated request, which are copies of all water bills I-70 received from the Public Water District or Bates City, wherever it's getting its water, dated July 1st, 2022 to the present. And finally, my original DR number 44, or the staff's original DR number 44, asked for copies of all lease agreements or contracts between I-70, Mobile City, and its tenants that were in effect in July 2022, the date that the DR was issued. I-70 sent no actual leases or contracts in response to that DR. Instead, it referred staff to copies of sample arguments it provided in DR number 16 and objected to the DR, saying the request was overbroad, burdensome, duplicative, and cumulative. Again, I-70 decided that relevancy of the information for the commission and the staff for itself when it failed to answer and provide the documentation. Again, that's not the party's role in this case. The judge and the commission determine questions of law, i.e. relevancy of facts to the law, not the complainant, not the respondent. To date, no copies of leases between the actual tenants and I-70 have been provided to staff as requested by the language of DR number 44. Staff is entitled to copies of these documents. They're relevant to the question of whether I-70 is providing water or sewer utility service to its tenants for gain and are likely to lead to discovery of admissible evidence. The language of the lease documents may state how or give information about how the tenants are billed for their utility service. Staff does not know that because I-70 has chosen on their own to not give staff the requested documents. I-70 doesn't have the right to make that relevancy determination. Because I-70's response to DR number 44 was insufficient and requires a full and complete answer, I-70 has a duty to provide the staff with copies of those lease agreements or contracts between I-70 and its tenants that are currently in effect. According to I-70's most recent responses to DRs 19 and 20, like I said earlier, there are 56 water and sewer tenants at the I-70 Mobile City Park. Therefore, there should be 56 lease agreements. That's 56 bills for water and sewer services for the past 11 months. I don't think that's burdensome or overbroad. That's information that's requested, is information commonly requested to determine whether an entity is operating as a utility. The central issue in this case is whether I-70 is providing water and sewer services to the public for gain and whether it's acting as a public utility. Those documents are directly relevant and will likely lead to the admission of evidence that will answer those questions. Therefore, I-70 should be compelled to provide the documents to staff without further delay. Thank you.
Thank you. I'm going to ask you a few questions now.
Sure.
Some of them I think I know the answers to, but all the same, I want to keep the record as clear as possible.
Sure.
Now, you had indicated as to DR 14 that the original request was for 5 years worth of bills, and the commission, or not the commission, I'm sorry, staff pared that back to request for just shy of 1 year's worth of bills. Is that correct?
Right, July 1st, 2022 to the present.
Okay. And is that same thing is true for DR 42, which would be bills to I-70 from the, either you had indicated the public water district or Bates City, and you're unsure as to which at this point?
Yes, yes,
And was that was also pared down from a 5-year request?
yes.
Okay. And in a DR 44, which requests the tenant leases, was that also for all leases for 5 years, or was that pared down as well?
No, that had asked for current leases.
Current only?
Yes.
Okay, I believe you said that, and I'm sorry I didn't.
That's okay.
Now, why do you believe that these bills will lead to admissible evidence?
Well, it will show if the bills might show if there's any extra charges added to the water or the sewer bills, whether there's any extra fees. It'll show it might show whether the rent is charged separate from the water or the sewer charge. We don't know. What we were given were sample leases that may or may not be used currently. We don't know what's actually being used. And to look at what's actually being used might let us know what I-70's actually doing.
Okay, in regards to DR 42, same question. Why do you believe that bills from the public water district or Bates City would lead to admissible evidence?
Well, depending on what the bill is from the water district and what the bills are that the tenants are paying, is there an added fee that the tenants are paying in addition to what is actually being charged for water? For example, is a charge for water $50 and then the tenants are being charged $60? What is that extra $10 for? Is that would go to whether I-70 is charging extra and obtaining a gain for that, is acting as a utility because they are charging extra for the service, for water service or for sewer service. But we don't know that without looking at the bills.
Okay. And same question in regard to the leases. How do you believe that those are going to lead to admissible evidence?
Well, the leases might show, there might be some language in the leases that talk about how they're going to be billed for utilities, whether they're going to be billed extra for water or sewer, whether their utilities are going to be charged separately, how they might be responsible for each charge that's part of their rent.
Okay, now I appreciate that staff has pared these down. And when I'm faced with a question of whether or not something is overly broad or whether it is burdensome, I generally ask myself, what is a sufficient level of discovery to accomplish what it is that the party is trying to accomplish? Is it staff's belief that this is the minimum, the minimum answers to discovery that would be sufficient for those DRs?
I think this would show, I think this would show enough to see how they've been acting. I think a year would give a good snapshot.
Would 6 months give a good snapshot?
Um,
And you may not know the answer to that.
I don't know.
Okay, so
I
what I'm getting from you is that you believe that
I think a
this is
year
the
would
sufficient
be
level.
sufficient, yes.
Okay, now you indicated that they have already answered DRs 19 and 20, or are the now 19 and 20, are those updates or are those answers?
Those were we asked for updated information to find out what, because the answer the answer that we had for 19 and 20 was was originally as of June of 22. And so we asked, what's the number of tenants currently? And they responded with April 2023, how many tenants they had currently. So that's.
Bear with me just a moment.
Sure.
Okay, Ms. Bell.
Sure, I will go through, since I think we've agreed that there is no longer a dispute as to DR 19 or 20. So I will forego arguments on that. But starting with DR 14, I think we need to back up just a little bit of background about I-70. It's a small company, as Ms. Kerr indicated. In response to DRs 19 and 20, I-70 indicated they've got about 50 tenants taking water or sewer service. So we're not talking about Ameren, a huge organization that has unlimited staff and resources. In fact, I-70 has no employees and has 2 owners who both live out of state. So when we're talking about burden on a small business, I think we need to keep that in mind, that that any additional discovery that would be required would require significant travel. And it's not like, there's just someone sitting there waiting to pull records in this type of entity. So it's different than a lot of cases that at least personally, I've seen at the PSC. In addition, I-70 received a questionnaire from the PSC, and that was back in 2021. And they were just inquiring about I-70's operations. There was no complaint on file at that point. And at that time, this was in April of 2021. And in that time, they had asked a number of questions and asked for a number of documents, which I-70 happily and voluntarily provided records, many of which we are at issue today. And so if you could imagine, in April of 2021, what I think the staff had asked for about a year of a lot of these records. So in general, I-70 provided backing up from records from 2020 and 2021 in an attempt to explain to the staff how I-70 was operating. So they pulled all these records back when they first were asked in 2021. Nothing happened for a number of months due to, I think, staff turnover and other internal issues. And so ultimately, there was a lack of communication, I think, between 2021 until around December of that year. And it resulted with a complaint being filed in April, I think, of 2022. So almost a year delay. And so when we're talking about, Ms. Kerr had said that she thinks a year of documents is sufficient. And that's really what I-70 has already provided. What the staff wants is they want a different year of documents. And that's why you have the exhibits in front of you. So if we look at DR 14 and what was actually provided, I think Ms. Kerr described it as 5 documents, but it's actually 120 pages of documents.
Okay, what exhibit are we starting with here so that I can catch up?
Exhibit 1.
Exhibit 1?
Mm-hmm. And I think Ms. Kerr indicated, it's just 56 bills. If there's 56 tenants, it's 56 bills, but actually it's 56 bills times for every month. They're monthly bills. So it would be 56 times 11 or 12. I think at one point she said 11 months. So that's not just 56 bills, it's quite a lot. And if we go through the answer here, and I think I'm on.
Which DR are we talking about? Are we talking about 44?
No, we're talking about 14, Exhibit 1.
Okay, I see it.
And in the first response, we provided a lengthy narrative about how the bills are produced. And in the last paragraph, we say once the number's calculated, the bill posts to the tenant portal. And so these bills are not mailed out. The tenants log in and basically their end of it, they can download what looks like a bill from their end, and then they pay it. So not only, we do not mail these out, and we do not have hard copies sitting in a file room somewhere of these bills. They're all through a program, some software. And so what we did provide, and so a basic tenet of discovery is you aren't required to provide you aren't required to make up documents that you don't have. And so these documents are through a portal that can be pushed out through the system, but aren't currently in existence anywhere in a paper form or a PDF form. You would actually have to go in to each client to each month and download out of that portal. Which is very burdensome for my client when you're talking about 56 times 12. So what we did try to but we tried to provide this. And again, this was provided in 2021. So if we turn to page 8 of the PDF, you see a sample bill. And what that is when the tenant goes into the portal. I'm sorry.
Pages aren't numbered, so I have to. All right. There we go. You said page 8?
Yes. And it should say.
That's including the first page? I mean, that's including.
Using the PDF numbers in the document. So you should see a statement at the top.
Got it.
Okay. And that is a sample bill. So if the tenant goes into the portal and clicks, I want to view my bill, this is what's shown, but essentially it's a shell that is pulling these numbers from the computer program into the statement. And Ms. Kerr said the reason why they want to view the statements is to know how much I-70 is charging and if it's marked up at all. And so this is a sample showing this is what it looks like. This is how those numbers pull into the bill. And if you want to know what the rate that's being charged, if you look down in the comment box, the bill shows this comment box, water usage times this rate, sewer usage times this rate. And so, here's the other details. And that's the same for every bill. It's just, the numbers change slightly due to whatever you're using. So that, if she's trying to calculate what I-70 is actually charging, this is evidence of that. If we turn to the next page, there are Excel billing histories for that same kind of mid 2020 to mid 2021. And again, it's showing the meter readings, the usage, and what the bill is, the water bill, the sewer bill, and the combined bill. And those are Excel histories, and there's a number of pages of those. The other documents that are provided, if you go to what is page 34 in the Excel document, you see a charge detail. And again, when you have these,
Hold on just a second. I want to get there. Don't know. Okay.
when you have these computer systems, they allow you to run certain reports. And so that's what I-70 was trying to do. I'm going to run a report that shows all the charges for that time period to show them this is what's going out on the bills. And so you have it for every month by customer for that entire period. If we flip again back to page 82.
Okay, wait a second.
Mm-hmm.
Okay.
You can see that there's a report called Utility Historical Consumption. So for the same period, it is pulling those readings, the previous readings, the consumption, the charge, the post date, and the account number. And again, that's everything that would appear on the bill. It's just in the format that the portal spits it out in. And that's for that period. You see 10/1/20 to 10/31/20. And I think actually it goes into page 1. And then I think the really important document is the last 2 pages. And this was the final document provided in response to 14. And that's something that when the staff first inquired about, again, pre-complaint and asked I-70 what's going on, they took all this, I-70 voluntarily took all this data and created this document to try to explain, here's how that all works together. And so what you see is,
And what page are we on now?
so 119, it's the last 2 pages of what was produced here in Exhibit 1.
There's also, you said 92?
I have 119.
Okay, sorry, bear with me. Okay, I see it. That's this colorized table.
And that's a summary that was created by I-70 to try to make sense of all this computer reporting out of this portal. And they've summarized by month for a year of here's the usage, here's how much we paid for the water, here's how much the tax was. So you'll note this also summarizes the Bates City bills. That's that first chart, shows the price, the tax, and how much they paid. If you go down to the next box, you're looking at what they billed the tenants by month and what the tenants paid and what the tenants didn't pay. And that first box is for water and the second box is for sewer. And so you're seeing basically they summarized all of the previous, 150 pages from the portal in an attempt to show what's going on with the PSC. So again, Ms. Kerr said what's important to her is what's the markup? Are they marking it up? And you can see here exactly what's going on.
Okay. Do you want me to ask questions about that now, or do you want to go on?
We can address those now.
Okay. I'm familiar that, that they, at least discovery rules, you are correct, do not require you to create a document or something that does not exist, but that doesn't relieve people from providing copies of things that they already have or that they can access. So let me ask this. Can the tenants individually download their bills? Are they capable of downloading and printing out their bill?
Are the tenants? I believe so. I think they could get into their portal and access their past billing history.
And is your client able to get in there and print out individual bills? I understand the argument that with a minimum of 616 of them for 56 tenants that that's a lot, but is I-70 even capable of doing that?
I believe I don't think printing them out is the right term. Like they're not sitting in a file folder where their bills exist and we could just print them out. We would have.
No, I didn't gather that to be the case. I gathered that this is some sort of software, but I would have to think that for the individual tenants' records, as well as, and assuming I-70 Mobile City Park is paying taxes for those records as well, that you would be able to access those.
You could go in and click like publish or download. It would then create that invoice that the tenant sees, and then you could save it and then print it. But right now, it doesn't exist.
And those individual invoices, do those show a breakdown of charges such as, this is the charge for pad rent, this is the charge for water, sewer, cable, whatever you have? Is that what
No,
I'm getting at is can the customer print out something that would resemble a bill from this portal?
that would be page 8 from the statement.
And that was that sample you had talked about before.
Mm-hmm.
Go there again. So this is what if an individual customer printed out their bill, this is what they would see.
Correct.
Okay. Bear with me just a second. I had another thought, but I lost it momentarily. Now you understand that that you had indicated this was all provided. A lot of this was provided prior to the complaint. Is that correct?
It was provided at that time, and then it was also provided in response to the DR. So all of this, if you turn to page, let's see, page 7, 6, and 7, right before the sample bill, you'll see our response on July 27th, 2022. And the second page says, see the following produced with this response. And all of this 150 pages was provided back in July. It was provided again. We had previously provided it, but we provided it again with the thought being, we've given this to you, we'll give it to you again, but to require us to just go in and do a different year, it's the same information. It's what we have.
And I'm not an engineer or anything like that, so there are large parts of utilities. They're complete mysteries to me. I'd see this thing at the bottom that says water usage times, and it gives a number, and sewer usage times, and it gives a number. But I don't know anything about those numbers. It doesn't say, gallons per minute. It provides no units whatsoever. Or no explanation of what, I'm sorry, it provides no unit explanation of what units correspond to those numbers.
Right. And so if you were to go to the meter readings and the usage, I want to say it's obvious once you start doing the math. I think it's in tens of gallons, right, Karen? I think you basically remove the 1,000, but you see this usage 561, and then you see the amount. Once you do the multiplication, it's on there. And if you go to,
That's the Excel.
Yeah,
Where it says gallons.
correct. There you go. And so I think they just dropped the 0 actually on the bill, which I think when we get into the Bates City water bill, you'll see also that they don't put the extra 0 on the end.
And he said there are 2 owners and they reside out of state.
Correct.
Who collects the bills for these?
I think the tenants pay online through the portal.
So everything is done through the portal.
There's an office, and I think you can pay at the office, but whether or not and who does that, I'm not sure. I believe most people pay through the portal.
You had indicated that they have no employees.
They do not.
Correct? Who's manning this office?
It is, they have some independent contractors. But if you think about a mobile home like an apartment building, many apartment buildings do not have someone sitting in an office 24 hours a day.
Okay, that's noted. And your objections to answering DR 14 are that it is overly broad and burdensome and not necessary. Is that correct?
That's one of them. The other one is it's asking for, if you specifically, if you look at the objection letter G, it's asking for documents that simply do not exist. It's also duplicative and cumulative. You know, they want a year, they have a year, you know, now they want a different year. But the information that they would need, or that the commission needs to decide this question, and we say in our response, nothing has substantially changed about the business between the time that we produce this and today. We can give the updated reports, but it's just going to be structurally and operationally the same.
Ms. Kerr, do you have the same PDF open in front of you?
Yes.
And on page 8 of that PDF, are those the kind of billing documents that staff is looking for?
Well, this is just one billing document. I mean, it doesn't have anybody's name on it or a unit number. So, you know, I mean, we can't verify that that's an actual bill to an actual tenant. You know, so perhaps this is, you know, this is I mean, this looks like a bill that would go out to a tenant, but this is the only bill that was provided to us. We asked for a sample, we asked for all the bills to the tenants. We got one single bill. And even if they provided bills for the year 2020 or 2021, that does not give us, you know, they can say that nothing's changed, but we don't know that. We can't verify that without looking at the bills, the current bills for 2022, number one. And we asked for the bills of all the tenants. We got a single bill with nobody's name on it, no unit on it. So no, this is not sufficient. This is not a sufficient answer.
Okay, let me further ask that. If it had a unit number, would that be sufficient?
Probably. If it had, yeah, I suppose it would be, if we got more than one bill, so we could, you know, and if we had the information from Bate City or the Public Water Service,
That's a different DR. I'm not
Right,
going
right,
into
right.
that right now.
but
Let me ask this then. So I see here account number, and there's nothing under that. I see unit number, and there's a hashtag, but no unit number. It just says I-70 Mobile City Incorporated at the top, and what I assume is the address of the park itself. Since both the above and below are identical, and there's no, Ms. Bell, why doesn't this have the unit, the account number, or any other information in regard to who?
It was meant to be a sample bill as to showing this is how every bill is created. And so it was meant to be an example. I believe the specific customer information was just redacted, I believe. But what it's meant to show is if you go to these other pages where it does contain things like unit number or consumption, the program pulls in that personal information for each customer.
Yeah, but without it on this, there's no way to match the sample bill to anything. But that's not really a relevant comment. Let me ask this. Hypothetically, if I were to agree that, as was indicated, the neighborhood of 616 bills was overly burdensome or too much to have your client print out, well, I'm going to start with Ms. Kerr, and then we'll kind of back this back to you, Ms. Bell. Ms. Kerr, if If I'm trying to think about how this would be done, if it could be done. Would staff be agreeable to a representative sample of bills for the relevant July 1st to present that would encompass something smaller than the 616 bills, like 100 bills? Would 100, I don't know how you would go about selecting random bills, or I know that's something that utilities sometimes do, but we're in a little bit of a different.
I think same. I think we had. I think a sampling would be fine. 120, 150, I think would be fine.
And Your Honor, can I ask a question?
Go ahead.
And I don't know that, I mean, I guess I don't know whether staff is seeking one customer over many months or just like one representative month. So for example, if we agree we have 56 tenants right now, you know, could we do 1 month of all the bills for every tenant? Because also if they're seeking, you know, these are transitory people. So even if they picked a customer and they wanted it over 12 months, I don't know that that customer is there for 12 months. So in my mind, if we're going to limit it, it would be more of pick a month and you can have all the, you know, all the tenants that are taking service that month. And that would be 55. I think that yeah, 64.
I think we'd want a representative sample of the year.
And that makes sense to me as well. I'm listening. I can see, Ms. Bell, I see your argument that people don't stay there a year all the time, and that things may change in regard to that. I would think that there would be a way to do both, that there would be a way to provide a few customers that have been there a year and provide their complete year-long lineage of bills, and at the same time provide a random spattering. So if you had, you know, let's see, if you're talking about, if you had 5 customers that had been there a year, having their complete bill lineage for that year, and then maybe having a representative month or two sample across. Would that be something that would work for staff?
I think so at this point, sure.
Would that be something? And I'm not saying this is what I'm going to do. I'm just kind of bouncing around ideas. Would that be something, Miss Bell, that your client would be able to do?
If we're talking 5 customers for,
A
you know,
year.
for a year, that, I mean, I think that's better. I think originally Ms. Kerr wanted everything in 10 days, and I'm not sure we could meet that timeline with 60 downloads, but we could certainly try.
I'm less worried about time at this point. I mean, this case has gone on for a while. What I'm more worried about is being sure that every side is getting the discovery that they need to do what they need to do. So
yeah, and I think we'll get into it when we get into the sample agreements, but in our mind, I think what Ms. Kerr is going to want to see is the bills of folks who are receiving water and sewer service. But once we get into the sample agreements, you know, if you're asking me what a representative sample is, a lot of the tenants at I-70 are RV homes or other folks who lease the land who aren't receiving any water or sewer service. And so when we're talking about whether or not you provide sewer service to the public, I-70 only provides sewer and water service to certain tenants under certain contractual terms. So if we were going to provide a representative sample of our full and complete tenants, it would include folks who are not receiving any water and sewer and are just paying pad rent. I'm happy to provide the water and sewer invoices to Ms. Kerr, but that provides an incomplete picture of the operations at I-70. Now, all of that has been explained in other DR responses, that that RV rentals are pretty common, and we're unaware of any RV park that where they, you know, just rent the land that's ever been, you know, had an issue with the PSC. And that's a pretty substantial portion of I-70's business. But we're happy to provide the invoices, where the water and sewer is being provided.
And I'm going to tell you right now, Ms.
Substantial.
Bell, that I have presided over rate cases that have involved vacation pad rentals and that for parks that also that serve, semi-permanent residents, permanent residents who rent for years at a time, and also have people that come and just stay the weekend and park their RV on a pad and access the utilities that way. So it's not. I've heard you make that argument a number of times, but I don't think it's unheard of. And I have presided over cases involving that.
There are several mobile homes on that property that are getting water and sewer. So there are plenty of bills for those mobile homes that you'll be able to provide.
Well, that's what I was getting to, is if we're talking about a representative sample, certainly out
You
of
could be able to
56
find them.
pads, I think you can find 5 that have stayed there a year or at least close to a year. And likewise, I think a smattering of other bills, if a representative sample were to be sufficient for staff's purposes, I would think that would be doable too. And that would be, and you had talked, Ms. Bell, about this being a little bit of a different situation and this being burdensome because of the size of the client being out of state. And so I'm trying to keep that in mind here while I look at this. Bear with me. I know I'm speaking in incomplete sentences. I'm aware of that.
No, and I didn't mean to be unclear earlier with respect to the RVs. I was talking about specifically RVs that don't hook up to any utilities. And so there are leases and tenants that have no access to utilities on the property whatsoever. I understand if the RV was hooking up to something, that's a different story.
Okay, thank you. Thank you for clarifying that for me. All right, is there anything else you wanted to say about DR 14, Ms. Bell?
No, Your Honor.
Okay. Let's move on to your objections to DR 42.
Okay, and in the exhibits that I provided, that is labeled as Exhibit 4.
Okay, hold on, wait just a second.
I'm sorry, which DR are you?
42?
42.
Okay, sorry.
And that's 19 pages, is that correct?
Correct.
Okay. Go ahead.
And this was the request for the Bates City water bills. And what was done was a provision of 1 year of those bills to I-70. You can see those are attached. And that is what was, again, we're talking about, they wanted 5 years, we gave them a year. This is the period for which we provided the other documentation that we just walked through. And the point was, what Ms. Kerr wanted to see was, is there a markup from what's coming from Bates City to the tenant bill, which is why that period matches up. But again, when we looked at that colored summary from the last exhibit, and you kind of saw that chart, this information is all summarized there, straight from these documents. And so, this taken with Exhibit 14 would allow Ms. Kerr to calculate what she said was relevant to her case. But these are the actual Bates City's bills. It shows the usage, the amount paid, the check number it was paid for, and you'll see that it matches up with what that chart. I think now, again, staff is seeking a year in, I think, the last 12 months. So again, our argument is we provided 12 months. We provided the 12 months that coincides with the other information we provided, so you can do the calculations you requested. If we provide this year, then they would need all the bills from the corresponding month to do the calculation they want to do. And so we felt like staff could do the calculations with the documents they received, and that we had provided them. Any requests would be duplicative, cumulative, and burdensome. As you can see, these are not electronically stored records. They are mailed records, and so it would likely require someone at the office to gather and photocopy these records. And so they have a year, they wanted a year, and now they are just requesting a different year.
I guess my first thing is it doesn't appear that the year really corresponds to anything, since it doesn't match up to any bills that are identifiable to any particular customer. As you indicated, these are physical bills from Bay City Water. They clearly have them, and there is a continuing duty to update discovery. So I guess I'm not really understanding your argument here as to, again, if everybody were to agree to a random sample, or if the commission were to order compliance with a sample that was somewhat pared down from the total number of bills, it would have to be able to, this data has to be able to correspond to something else. So if you're providing data from tenants for the year of July 2022 to now, that it's not going to correspond to any of the Bates City water bills that have been provided here. So I don't think that any calculations could be done between those two that would have any sort of meaning.
So if we flip back to the last 2 pages of 14, the calculations there are done for the period 2020 and 2021. And so like we had argued that, all they need is 1 year, they had 20 and 21, this corresponds with that period. So they could conduct the calculations because what was provided under 14 and what was provided here under 42 was the same period. So if we look at that chart and you see tenant billing, payment, non-payment, you see the water bill, the final bill, and what the tenant paid. So you can see how those match up. If the commission were
For
to
that period of time, but not for the period of time of the complaint.
Well, the complaint's ongoing. So should the commission order additional bills to be produced from a different time period, I guess I would concur that you would need the Bates City bills from that same period in order to do the calculation.
And there's not 616 of those. So yes, somebody would have to copy them. Yes, somebody would have to find them. But I would think any business would be expected to retain these relatively retrievable anyway.
Yeah, I mean, if the commission wants us to produce those, we have copies of our records. We are organized, I guess. The point was small business. We provided a year of both the bill, the computer records, and the Bates City bills. And if this goes on for 2 more years, what stops the staff from coming in 2 years from now and says, now we want 2024? And so we were just taking the position that we provided a year in both circumstances. Again, I would concur with Your Honor that if you require bills from 2022, that the staff would need the Bates City bills to correspond to make that calculation. We were just saying they already have it from 2020, 20 and 21, nothing's changed. They should be able to do the calculations and make their arguments based on that year.
Okay, and I see that, and that's your assessment. That may not necessarily be the commission's assessment. I do agree that, if this were to go on for 2 or 3 or 4 more years, certainly then it becomes very problematic for your clients to continually answer discovery requests on a case that's not moving.
And one other thing, Your Honor, I would agree that, this request in isolation looks like not that much work. But I would say, I think we're at 58 DRs or maybe 60 with all of the supplements, and we provided more than 300 pages of documents in multiple tranches of DR requests. So in isolation, copying the Bate City bills is not, if that was the only thing that we were asking to do, I think we wouldn't be saying, oh, this is, overly broad and burdensome. But given that this case, again, only involves 50 people in a mobile home park with a business that has barely any resources, 400 pages, 50 plus DRs in totality has been a significant burden on the company and on its resources and on its person.
And I'll bear that argument in mind. I do think we are talking about, I don't know, because I'm not part of the discovery process between the parties other than in this capacity. So when we're talking about 11 or 12 bills from Bate City Water just to update discovery as required by the rules to current, I'm a little lost there, it seems. And as I indicated before, I mean, thousands of pages of documents are meaningless if they don't correspond to each other, if there's no way in which they relate. I mean, if you have documents from the 1700s and documents from 2020, even if they're covering the same items, there's virtually no relevance at all to each other. So I do see staff's point in regard to this. So did you have anything else you wanted to say about DR 42?
No, Your Honor.
And from staff's position, I'm gonna, these 19 pages with the bills from Bate City Water, are these the kinds of bills that staff is looking for in response to their DR?
Yes,
Okay, so it'd be, you're just looking for these kinds of bills that would be from the July 1st, 2022 date forward.
yes, and really the only reason I added this to this motion is because, there's a duty to update, and I asked in an email, could you please update this? And I never got a response. And that's why we're here today on this. I mean, this could have been resolved a long time ago.
Well, that's a continuing problem. That is something that carried over from our last
Right. So,
from the
yes,
last
this
one.
is exactly what we want. We just want updated information. That's it.
And I just want the parties to communicate. So I get I am concerned when it appears that the parties are not communicating. All right, let's go on to DR 44. And those are the leases. Ms. Bell, if you want to go over your objections to providing those.
Sure. The staff has requested all of the leases for all of the tenants. And as I indicated, the tenant leases, the tenants are somewhat transient. And so we seem to be stumbling over this point. And I think their original request was currently, give us all your current leases. And so is that the month that they asked, is that supposed to coincide with the period of the bills that they've requested? And so it seems to be an issue. And now, of course, we're a year later. So is it now today current? And at what point am I, continuing to provide these, especially if we've got folks coming in, for an RV rental for the weekend, for 2 days, am I then needing to produce all of those? And so it's just, again, there's no one, it's not a huge organization with a lot of resources or employees. And so we thought the best way to do this is explain that, if a customer were to come into I-70 today and want to lease, these are the agreements that are used. It's like a sample bill, but a sample agreement. This is what they sign. These are the forms of the tenants on the property. And so the response is, when a guest or tenant at I-70 inquires about service, they are presented with the following agreements, and they get to choose. They can choose to take and so if we can flip to, we're on exhibit, I think this is exhibit 5.
Okay, hold on while I pull it up.
Okay.
And that's 18 pages, is that correct?
Yes.
Right.
And so depending on what the needs of the particular tenant,
And this is
the,
I'm sorry to interrupt. This is a sample lease agreement with I-7, correct?
I think there are 5 sample agreements here.
What makes these agreements, just so that don't have to spend time reading through them during this hearing? Okay, I see. So there's a short term, a per week. So there's 5 agreements because there's 5 different, and you indicated no utilities. That would be this boondocking one.
Mm-hmm.
Okay, I think that clarifies it to me. So these are representatives of the different kinds of rental agreements that I-70 Mobile City has.
Yeah, depending on the needs of the tenant. And so at any given, at any given time, this question phrased as staff has asked it could be slightly misleading if we provide current leases, because you don't know the full offerings of everything. And next week someone might sign, one of these that you didn't see if I just gave you the current one. So this is what's here. We're happy to provide the number of tenants that are, and we did provide in a separate question, how many people are receiving utility services versus RV versus tiny house versus boondocking. We can take that snapshot on a day, but this is what this is what they're being offered, the full spectrum, and they know how many tenants are at the property. So we have responded.
And admittedly, response is a range. It is a range, and I would say that this would fall on the minimal side of that range. You have provided leases, and you've provided leases for different kinds, which I think falls under the minimum of that. But I guess if you're providing leases, what I don't understand is why you didn't provide leases. Well, no, scratch that. I'm not even going to go into that.
So I will say, and in a separate DR, not only did we provide the sample leases, we also identified how many of which types of guests were on each lease at the time when they asked currently, with a snapshot and a date, and said, we've got this many tenants on this many tenants on, boondocking versus receiving utility service versus one tiny home. So we kind of described the snapshot on that date of what the park looked like. But obviously, depending on weather and seasonality, that changes.
And this is kind of for both parties, because here's kind of what I'm hearing. I asked for this, they gave us that, and from the other end, I'm hearing they asked for this. That is overly burdensome because of the way it's done. But it doesn't appear that what I'm not seeing is it doesn't appear that I'm going to get back to communication. It seems to me that there would have been some way to work this out without involving me to this extent. And getting back to my idea of a representative sample, and staff, I like I said, I see in regards to what they've said would lead to admissible evidence and what they're asking for and why it is. But still, I also see your argument as to why, if you've got somebody who's staying a weekend or somebody who's staying, but I guess I'm having a little difficulty in, if you provide somebody's weekend lease to staff and they're gone, you've fulfilled your part of the discovery thing. And then it's kind of staff's problem that the person is no longer there. But with a representative lease, that's not the case. And it doesn't, while it may correspond to their leasing practices, it is not a lease tied to any particular place that may or may not be receiving utility service. And that's where it becomes a bit of an issue. However, and I said, assuming, that that a representative sample would be sufficient, where you're talking about 5 tenants that carry all the way through for a year, and some other representative bills that would go across these various groupings of, short-term, RV, boondocking, etc. It would seem to me that would be something that could be provided without being overly burdensome. Would you agree with that? And you don't have to. I'm asking if you do.
I mean, I don't agree that it's not, I don't agree that it's not cumulative and duplicative, since we provided the sample agreements and the numbers of everyone that's on there. And then the other objection that we raised is just simply relevance. I mean, you don't have to have a lease here. So nothing about the lease changes the nature. If I don't have a lease and I'm providing water and sewer, the staff could make the same argument. So based on the billing. So it's just irrelevant to the ultimate question of law about whether or not we're providing water and sewer. It doesn't say, are you providing a contract for water and sewer? It just says, are you providing it? So whether or not, or what the contract says, I think the commission's going to look past that and look at what we're actually doing, which they have that information. And again, the contract or lease, there's no allegation that we've violated any sort of contractual or lease provision to the extent that there are contracts or leases. And so I don't see how the contracts are relevant to the commission's question of whether they have jurisdiction.
Jurisdiction is not the question before us in regard to a motion to compel.
But relevance is, and I think the
Yes,
question
but that's,
here,
again, that's not your determination to make. You're free to object that you don't think it's relevant, and you can explain to me why you don't think it's relevant, but that's the commission's determination.
yes.
I just want to be, I want to be where I for a second there, I didn't know where you were going with that. I thought it sounded like you were confusing the staff and the commission, and there's certainly a wall between those two entities. And I'm aware that you have other objections, such as duplicative and such as relevance. But those are not anything when I'm trying to look at what I think is reasonable in the way of discovery. There's no way to reasonably move whether something is or isn't relevant. Either is or it isn't. So that's those I will I'll hear your arguments and I'll address those, but you're not going to hear me ask questions about those.
Okay.
Could I say something?
Give me just a second. Would you agree that a representative sample of leases would be less burdensome than all leases for a year?
A representative sample over a year or a representative sample of 5 years?
I'm not talking about 5 years. I'm saying if I'm trying to relate these together. So if you're talking about, you're going back to DR 14 and you're talking about 150 bills, and you're talking about possibly 5 year-long tenants over the course of a year, and you're talking about a representative, as you had indicated earlier, monthly sample of other tenants that doesn't necessarily follow their legacy of bills throughout the year. That again would need to correspond to something, and that would need to correspond to the leases of those tenants. That would be that seems like that would be extraordinarily relevant.
So I think if what I'm hearing from you, if you picked, 5 people, John Doe, A through E, and then in conjunction with their monthly bills, we would also provide leases for those customers. I would consider that less burdensome than providing all of the leases.
Okay. I apologize, Ms. Kerr. I had stopped you because I wanted to get that before I forgot. What did you want to say?
Well, two things. First of all, I think after this DR went out, over the course of time, I think we've tried to make it clear that we just wanted to get copies of the leases that were in effect for the water and sewer customers at that time. Not, I don't think it was an open-ended, just get copies of leases, whenever. And my last email that went out before this motion was filed in our last discovery conference, I said, please forward the leases that are currently in effect. Whatever is currently in effect at that time, that point in time, for those 56 water, and, found out a week or so after that email went out, those 56 water customers. What we just want to know what those leases say.
So, okay, so
And, and when we filed the complaint and I filed the DR, what were the leases in effect at that time the DR was filed? That was the question. It wasn't an open-ended, keep filing leases with us as, every day, every week, every month. It was please give us copies of leases that are currently in effect. That's what it means. That's what it meant then. That's what it meant when I asked for the updated ones. That's what it means now.
Ms. Bell, is that what you understood it to mean? Or did you?
No, because I've heard a lot today that I'm under a continuing duty to supplement. So I would assume, just like the bills, if I would have provided all of the leases in 2021, we'd be before you asking me for all the bills from 2022 or the leases from 2022. We've heard that multiple times today. So no, that's not how I understood the request.
Do you think?
You can call and ask. I can tell you, and my email says currently in effect.
Which at the time of the email would be different than at the time of the request. And so maybe.
No, and if you'd answered
Hey,
my
hey,
email.
stop. I
Sorry.
don't want you guys just bickering back and forth. If you want to bicker back and forth, you can do that on your own time.
I apologize. Sorry.
This is, as I indicated, I have frustrations when parties don't communicate with each other, and I think it.
I apologize.
I'm not asking for an apology. Thank you. I understand. Okay. As you understand the request now, Ms. Bell, lease is in effect for when the DR was filed. Is that an answerable DR for you? Let's assume for the moment that wouldn't require any updating. Let's just assume that. I'm not saying that that's the case.
I think what we've been talking today, Your Honor, about is to try to get everything in the same period. So we're talking about the same profile. And so if we are going to provide bills for the last 12 months and we're going to provide Bates City for the last 12 months, then I think an answerable DR for me would be to provide today current or January 1, 2023 current leases, not 2 years ago.
No, I understand that. Okay. And again, this is hypothetical. I'm not ordering anything today. So from staff's position, if we're talking about this July 1st, 2022 period moving forward, if hypothetically staff was to pick a day in there and say for I don't know, St. Patrick's Day, for March 17th, provide all the leases that were in effect at I-70 Mobile City Park on March 17th. Is that what you're looking for? Something like that?
Yes,
and that would be sufficient.
yes.
Is that something? And I'm not addressing your other objections, Ms. Bell, because I'm aware that they're out there as to all three DRs. But is that something that that you would be able to provide?
To the extent there are leases on that day, I believe I could. I believe I could. I'm not sure. I think my preference again would be a representative sample. But I believe there are signed leases available to copy. Whether there's one available to copy them, I'm not so sure.
Yeah, and
But I
understand your argument. I mean, theoretically, on any given day of the year, there could be nobody in the park. There could be
Correct.
zero leases. I mean, probably unlikely because then it's not really a business. But so that number could theoretically, that number could be 56, that number could be 12.
But I think we could provide, a representative sample.
Okay. Well, what I'm saying is if you're providing 5, and again, I'm going back to my hypothetical with that second thing. If you're providing 5 customers with a year's worth of bills for those customers that have stayed their year, and over that year you provide all the leases that were in effect over March 17th, those should cross. That's correct, right?
Right. They should. And at that point, I would ask that the request be limited to those 5 customers because they match up. Because I think another goal here too is to protect is to keep as many documents public as we can. And once we start getting into customer specific information, I'm going to have to start redacting or marking things confidential as we go forward. So, I mean, my preference again, as someone who values individual privacy, is if we're focused on 5 individuals for the billing, that we provide those 5 contracts or something less than the entire universe. But again, we will follow the court's order or the commission's order to our best ability.
Okay, and I'm certainly amenable to your concerns over privacy, and I would have no problem doing an entire hearing in camera, except for the hello, here we are today, let's go on the record, and we'll adjourn for the day. So I certainly understand privacy concerns, but there's got to be a way that information can be shared and yet still adequately address those concerns, and yet comply with Missouri's discovery rules. And Ms. Bell, I'm sorry, I've interrupted you a number of times to ask my questions. You've been very gracious about it. And so if I've cut you off or prevented you from saying anything you wanted to say about these DRs, I would like to give you an opportunity to address anything further that you would like to address at this time.
No, I think that's it. I think we had voluntarily provided year documents where it was, time limited, and voluntarily provided all of the sample agreements. We've been doing our best given our limited resources, and we appreciate your time today.
Okay. Anything further from staff?
No, you had asked about the date. I think ideally, if you were going to pick a date for the leases, the response, since we got the response to DR 19 on April 26th with the 56 tenants for both water and sewer, I think that would be an ideal date.
April what?
Because, I think April 26th, 2023 would be an ideal date for those leases, just because that's the date that we got the DR that says there were 56 tenants that had both water and sewer service. So that date would correspond with the number of tenants that had that. So we know there would at least be 56 tenants. Now, whether there are 56 leases on that date, I don't know, but that would probably be an ideal date. But other than that, I don't think we have anything else. I think we've gone through everything that we need to, and
I just have one additional request, Your Honor, that follows the motion to compel. And we've talked about this before, but we talk about how my motion for summary determination has been sitting for some time, and that the staff's response, the commission stayed the staff's response time. Since this is the staff has indicated this is what they need to move forward, and we intend to comply with whatever order you make. We'd like to go ahead and get a response date from the staff on that summary determination and a hearing date to decide whether the commission has jurisdiction.
I don't think that's unreasonable. I do think that the rule says that it can be stayed for a reasonable amount of time. It does not define that reasonable amount of time, but it does state until discovery is concluded, I believe, or something to that effect. I would have to look it up. My concern is we've had multiple discovery issues that have needed to be addressed by the commission now. And so I'm reluctant to order staff to respond to a summary judgment order until I know that discovery's been completed and they've had an opportunity to look at the information.
May I propose a solution? Your Honor, I could file a motion to set that date at the time at which I respond to the discovery, and then that would allow staff 10 days under the normal rules to review my responses and to reply to my motion on whether or not they find my responses insufficient. And that might be a way to move forward that staff then could alert you if they're uncomfortable with my responses.
I don't find that unreasonable. Ms. Kerr, do you find that unreasonable?
not at all.
And I don't know at this point what the commission will decide, but I certainly will be putting this in front of them. Okay, I don't have any further questions at this time. I'm going to ask one more time, is there anything else that the commission needs to address at this motion hearing?
Your Honor, can I offer exhibits 1 through 5 so they're part of the record?
I'm hesitant to do this at this time, and my reasoning for that is this is a motion hearing. There's no witness offering this. There's no foundation for it. Let me ask this question. Staff, do you have any objections to admitting these exhibits for the purpose of this motion hearing?
Yes, I object that, first of all, these DR responses, they've been filed already in EFIS. I think our arguments are, since it is a motion hearing, our arguments are sufficient to allow you to make any determination that you need to. If any of the DRs or the DR responses need to come in, they can come into the hearing. We just received this, right before the hearing anyway, but I don't think these are necessary. I don't think, like you said, there's no foundation, there's no witness to offer the exhibits. I would object to them.
Okay, Ms. Bell, any response to that?
I would just argue under the statute, under 536.070, that it's an agent. I mean, Ms. Kerr admitted that they were filed in EFIS. There's no suggestion that they aren't the originals. They are an agency record at this point. And so I'd at least ask the judge, ask Your Honor to take notice of the documents because they are a record of the agency.
And you're talking about that, under 536, you're talking about the discovery rule that says that, that records of an agency come in by themselves, correct?
I believe so.
That's kind of the summarization of that.
It's my understanding.
I'm going to sustain staff's objection at this time. I think that if they're in EFIS and you clearly have them, that they can be offered at any evidentiary hearing, and that I do have the sufficient information I need to respond to the motion and objections. So that'll be sustained. Anything further before we adjourn?
Nothing.
No, Your Honor. Thank you.
Thank you both for your time. I appreciate it.
Thank you.
And we are adjourned. Let's go off the record. And Kayla, you can stop recording.
Thank you.